Welcome to Washington Legal Foundation's web seminar. I'm Glenn Lammy. I'm Chief Counsel of the Foundation's Legal Studies Division. For those of you not familiar with the Foundation, we are in our 43rd year of free enterprise advocacy and education. Programs such as this are one of the things that we do on our communications side. We also litigate extensively in the federal and state courts, file regulatory comments, initiate regulatory proceedings sometimes, and have some original litigation in addition to our amicus practice. We also publish on a wide range of issues that affect the free enterprise system. The area of scientific evidence has been one that we've been extremely active in. The product that our speakers today produced for us is, I think, our fourth monograph on the issue of scientific evidence since the Dalbert decision came down. We also have issued a number of shorter publications. We have a blog that has Evan as one of our regular writers on scientific evidence. Just yesterday, we posted a piece by one of our other expert commentators on a decision from the district court in Minnesota on the 3M bear hugger MDL, which I encourage you to check out. So we definitely are very active in this area. In a 1996 opinion, Judge Richard Posner quipped, "The courtroom is not the place for scientific guesswork, even of the inspired sort. Law lags science. It does not lead it." That sentiment, which should probably be embroidered on a pillow and put in every federal judge's office, is one that Washington Legal Foundation certainly embraces. But at the same time, we also certainly acknowledge that law and science are inextricably intertwined in our legal system. And perhaps one of its wisest and most impactful group of decisions, the U.S. Supreme Court dictated that judges, not lay jurors, should determine the reliability and relevance of scientific and other expert evidence. The scope of this gatekeeping has expanded since the 20th century when the court decided the Joyner case in 1999, the Cumho case in 1999, and the challenges judges face when making admissibility decisions has grown as well. For that reason, we asked our longtime friend at the venerated Mayer Brown law firm, Evan Taker, if he'd like to put together a monograph providing guidance for judicial gatekeeping. He assembled a team of practitioners with different backgrounds and skills, and on January 15th, WLF released the fruits of their labor, which is the monograph that's shown there on your screen. Today's program both delves into that monograph and builds on its teachings. The monograph's target audience was judges. Today's program will discuss how practitioners can help judges make the right evidentiary decisions. Joining us, as I noted earlier, Evan Taker, who's a partner at the DC office of Mayer Brown. He's a co-leader of the firm's Supreme Court and appellate practice. He's been integrally involved in a range of issues of paramount importance to the business community, including punitive damages, class certification standards, admissibility of expert testimony, and enforceability of arbitration agreements. As I noted, he's the featured expert contributor on judicial gatekeeping of expert evidence for our blog, the WLF Legal Pulse. He's also the editor-in-chief of Mayer Brown's blog on punitive damages guideposts. Joining us also today is Craig Woods, who's also a partner at Mayer Brown in their product liability and mass tort litigation practice. He's an experienced trial lawyer with an electrical engineering background and thus brings a highly specialized set of skills to litigating claims based on technical and cutting-edge issues in science and medicine. Prior to joining Mayer Brown in 1995, he clerked for the Honorable William C. Connor of the Southern District of New York. This is going to be mostly a question and answer session, which I'll be asking some of the questions, but I also encourage those who have joined us today online to send in their questions by using the Q&A mechanism that appears to the right of the view screen. I am going to settle in our audience and we'll get the questions started. So gentlemen, each time the Supreme Court has issued a decision on admissibility of expert evidence, it's broadened judges' gatekeeping responsibilities. What reasons has the court given for affording such authority to judges?
Well, I guess I'll start on that. There are a number of different intertwined reasons why the gatekeeping function needs to be performed by a court and not just thrown to the jury. First and foremost, juries can't be expected to sort out the kind of complex scientific, economic, and other testimony that they're going to be confronted when an expert witness testifies. At the same time, juries tend to give expert testimony extra weight in weighing the evidence in front of them. The experts come with the witnesses come with a guise of expertise that gives their testimony outsized importance, and so it's quite incumbent on the judge to make sure that if the jury is going to give weight to expert testimony, that the testimony be reliable. Now, I think what's not said explicitly, but what's really underlying all of this, is that the whole business of obtaining expert testimony is one that sort of is at risk of not adhering to scientific neutrality. The lawyer calls an expert in the expectation the expert is going to provide the opinion they need to win their case. And oftentimes that results in testimony that not only is unreliable, but is sort of designed to sort of provide the plaintiff lawyer with sort of a second voice for the theory of their case. And so for all of those reasons, I think it's absolutely critical that the courts step in, evaluate the testimony, make sure that the expert testimony meets scientific standards, and that it is confined to the topic that is appropriate for expert testimony and doesn't spill into the role of either the judge, the jury, or the lawyers. You want to add anything?
No, I think you've captured it well. I think one of the dangers in expert witnesses is they have very broad latitude in the testimony that they can give. They're not just giving their own personal information. They can rely on evidence that's not even admissible. And because of that, and that's why I think lawyers use experts in these cases, is it allows them to be a mouthpiece for their theories of the case. So Dalbert is a way of controlling that, because lay jurors don't have the tools in their quiver to evaluate the reliability on their own.
So staying on gatekeeping for a moment, one of the key decisions courts must make is weight versus admissibility, and you devoted a section in the monograph to that distinction. On that, judges decide whether to assess the expert evidence themselves or whether to allow a jury to evaluate the evidence's importance. Why is this such an important determination, Evan, and then also Craig, what can defendants do to make sure the courts get that determination right?
Well, it is important because if the court just throws this decision to the jury and says it's just a matter of weight, it's basically abdicating the function. The jury isn't equipped to determine whether things that an expert witness is saying should be given weight or disregarded if it has to do with complex scientific evidence, economic evidence, evidence about a specialized field. Those decisions need to be made at the gate, as the term reflects, not pushed back into the house, so to speak. So it is an absolutely critical distinction. And let me give an example that I think Craig can maybe move forward with is differential etiology, which basically is an accepted scientific means for determining whether or not a particular substance caused the plaintiff's injury, and it requires ruling in all the potential causes and then ruling out the ones that couldn't have caused the plaintiff's injury, and only if the only one left after that process is the substance in question can the expert credibly testify that it is the cause of the injury. But if an expert is sort of playing fast and loose with the ruling in and ruling out process, you can get a very skewed analysis. And to say, well, whether or not the expert appropriately applied this methodology is just a matter of weight for the jury, it's basically defeating the whole point of the inquiry.
Yeah, I think there's a threshold question that has to be answered to determine whether it just goes to weight or whether it's a question of admissibility, and that is, was the opinion derived using a scientific methodology? A jury is not equipped to answer that question. The court is required to answer that question, and it involves two kind of sub-issues. One is whether the scientific methodology was used, and then second, was it reliably applied? The example that you gave, Evan, about a differential etiology. Were they really ruling in properly the substance in question as one of the causes? Were they really ruling out the other causes? Those are questions for the judge to make in the first instance before we even get to the jury. And I've seen a number of times where judges feel, well, they've raised some great arguments for why it's not a valid methodology. I understand the arguments that are being made, so let's just let the jury decide who wins those arguments. But the point of Dalbert is that's not the jury's role to make those calls, and they aren't equipped to make those calls. And certainly judges, some judges may be intimidated by having to make those calls, but the judges have many more tools in their toolbox to address that issue. I think we're probably going to talk about that a little bit later. We certainly talk about it in the monograph.
Right, yeah, absolutely. We'll move on to that right now, as a matter of fact. Dalbert hearings is one of the tools that you wrote about in the monograph. At what point during the pretrial process would a defendant decide to seek a Dalbert hearing, and can judges themselves sua sponte initiate a Dalbert hearing?
Well, I can answer that first. So I think it depends on the case. There's no fast set rule as to when you have to have a Dalbert hearing. In very complex cases, courts have been very receptive to front-loading some threshold issues, such as general causation or requiring plaintiffs to come forward with expert affidavits to support their claims before moving into later stages of discovery. Some of these case management orders are referred to as lone pine orders. And particularly in MDLs or cases where you have multiple plaintiffs, courts have been somewhat receptive to requiring plaintiffs to kind of at least establish up front that they have prima facie evidence in a case. And in some cases, the courts have held Dalbert hearings at the initial stage. I think most commonly, in the cases I've been involved with, at least, Dalbert motions are heard around the time you do motions in limine prior to trial. But another issue is, and maybe Evan could comment on this, is in class certification hearings, to what extent do you have a right to challenge experts under Dalbert? And is that a place where Dalbert should be employed in testing the reliability of evidence?
Well, I guess I'll try to address that then. I have been involved in a number of class actions where the plaintiff side in particular is using expert testimony in an attempt to show that the issues can be litigated on a class-wide basis. And it can arise in every kind of class action imaginable. We're doing one right now in the Fifth Circuit, which is up on appeal, involving releases from a chemical plant during Hurricane Harvey. And the plaintiffs put forth multiple experts to try to persuade the trial court that they could prove exposure, injury, causation, and damages all on a class-wide basis. And our side naturally was taking the opposite position and challenged the experts' testimony, each of the experts. And the judge held that at this stage, it wasn't necessary to conduct a complete Dalbert inquiry, and instead to look at whether basically it was almost like a soft look at whether there was enough there to hypothesize that potentially the plaintiffs could prove their claims on a class-wide basis. And that's one of the issues on the appeal. The most courts, I think, have held that you have to apply a rigorous analysis at the class certification stage, because the class certification decision itself must be based on a rigorous scrutiny. So it makes no sense to say you can certify a class on less than that when it comes to relying on expert testimony to support certification. So I think there's a circuit split on the issue. It may need to be sorted out eventually by the Supreme Court, but we believe that we're on the right side of that. It makes sense. It's consistent with some of the things the Supreme Court has said in its class certification decisions. So I think that's one people should keep an eye out on and make sure the issue is properly preserved in litigation and then argued, if necessary, on appeal.
So for a successful Dalbert hearing and obviously the discussion of science in any part of the litigation, you have sort of two sides, the lawyers and the judge. We'll address the lawyers first. How critical is it to have someone who is not only legally conversant with the issues at hand, but also the scientific issues at hand?
Well, I'll start. I think it's exceptionally critical. First of all, putting aside Dalbert, if this is going to be part of the case, the lawyer has to know it. The lawyer has to become as knowledgeable in this area as if he or she had a degree in the area, because you can't explain it credibly to a jury if you don't understand it well enough yourself. The job of the lawyer at trial and on appeal as well is to be able to take complex, specialized information and translate it for a generalist jury, a generalist judge, a generalist panel of judges. You can't do that unless you understand it well yourself. And then at the hearing, that's just front-loading it. And it seems to, at the Dalbert stage, it seems to me the more that the lawyer understands it, the better chance they have of persuading the judge that the expert is not applying a reliable methodology. And that's frankly why I think we're so fortunate to have Craig on our team, because with his science background and his deep understanding of the scientific method, it's an easy learning curve for him, even when it's maybe outside his original area of expertise, which was electrical engineering, I believe. So being conversant with that, I think, is absolutely essential at each stage of the litigation.
Yeah, I think it goes to credibility with the judge and with the jury. You're trying to persuade the judge, you have to do that in a credible way. And if the judge realizes you know what you're talking about, and you're giving him the straight interpretation of the science based on the evidence that's before him, that increases your chances of getting a positive result.
So on the judge's side, we actually have a question from a viewer that I think fits in very well. So that if judges don't have knowledge or experience in a particular scientific area, what obligation do judges have to become knowledgeable in the area?
Well, obligation is a strong word. I mean, I believe a conscientious judge would want to get the necessary understanding, and there are lots of different ways to do it. We talk in the monograph about, judges can choose, if they have 3 law clerks, they can choose to hire one with a science background or an economics background if they know they are going to have a complex case. They can hire someone like that as a special master. They have they have a range of options. They can choose to study it themselves. They can get a book. They can hold a lengthy hearing in which the lawyers are forced to explain it to them in a way they can understand it. But it is important that they take the time and make the effort in one of these ways. And then, we'll probably talk later about court-appointed experts, which is a slightly different variation on this. But I wanted to give Craig a chance to just add on to this other stuff first.
Yeah, let me add one thing to that. One of the things that we've seen often, particularly in MDLs, is that the judges will schedule something called a science day, which is just a kind of an education forum for the judge. And I've seen this done in several different ways. Sometimes you actually put the experts on, the attorneys do. I recently participated in an MDL where the judge requested that experts present the science to him and would not allow any of the attorneys to say a word. He wanted to hear it directly from the experts, and it was basically a conversation between the judge and the experts that was completely off the record. The judge was not going to allow any of the parties to later use any of the testimony in any of the proceedings. But it was a way for the judge to try to get some candid, unfiltered, I think, responses to what is the state of the science. So there, as Evan says, there are many ways a judge can get up to speed. Under Dalbert, they are required to make these calls. It behooves them to learn the science as much as they need to, at least to try to glean whether the opinions of the experts meet the proper standard for admissibility.
So on the use of independent experts that are appointed by the judge, what downsides are there to that? Obviously, there's upsides, but nobody talks much about what the downsides are.
Well, I think parties have been reluctant to really push for independent experts because of the lack of control that they have of the experts. I mean, the expert is your witness who's going to, that you hire is your witness who's going to put forward your theory of the case. Hiring an independent person kind of takes you out of control. You certainly may have a lot of faith in the science, knowing what the evidence is, but unless you know that the person who's going to be chosen as the court-appointed expert is really a neutral person who's qualified and reliably will apply the science, maybe you're buying another witness who's going to put forward junk science. It's hard to know that up front. So I think that's the reason people have been reluctant. So I think the critical issue is, what can you do to give yourself some comfort that when you get a court-appointed expert, you're really getting the right quality person who's going to properly apply science.
Yeah, and we were discussing this a little bit this morning before we walked over here, and I think it's an interesting challenge for people who believe in scientific neutrality to try to set up a system in which both sides can have confidence that by ceding control, in a sense, they are still going to have a fair outcome. And so it's really critical, if the court wants to go this way, you're going to have to go along. So, and I was saying to Craig this morning, if I was a judge, I would want to do it, because I know enough about how experts get hired to want to see a more unbiased opinion. And so then the question becomes, what mechanisms do the parties have for ensuring that you don't just get somebody who's already in one camp or another? Certain issues are subject to debate. For example, what's the cause of diabetes? Is it too much sugar or too much fat? There's a big debate in the medical community over that. And, so there are some subjects as to which there's legitimate disagreement. A lot of the stuff we've seen, we don't really think there's a good argument on the other side that they are really having to reverse engineer from the outcome they want to the methodology that they're going to apply. And in those circumstances, we would like to find a way to have a neutral, respected, independent expert say that. And so how do you get there is the key question. I think, you can start, I think, by having a sort of dual-layered process where you've got a panel of experts who themselves then select or recommend to the court, which is much the same thing, who the court-appointed expert ought to be, and that panel needs to be drawn as well as possible from a sort of neutral group of experts in the field. And so how do you go about finding that, and are you going to be able to get enough consensus between the parties to make it happen? But I think it's worth continued effort in this area, because I just seen, the book is filled with cases involving testimony that got thrown out, and that's just the tip of the iceberg. There's so much result-oriented expert testimony out there that having a different way to tackle the cases in which expert testimony is truly necessary. There is a whole body of case law that have thrown out claims because of a lack of expert testimony. So you've got courts saying, for this kind of claim, you need an expert witness. So we're not going to sort of change the way we look at how to prove a tort case. We're going to have expert witnesses. And so then the question becomes, how can we maximize the chance that the jury's not going to be bamboozled?
And I'll say, if I'm from a judge's standpoint, I agree with you, Evan. I'm surprised judges don't do this more often, because certainly in a number of cases I've been in, it just seems to me the judge is somewhat overwhelmed by the testimony and the disputes, and the judge feels timid about stepping in the middle of that to say, no, you didn't. I'm not an epidemiologist, but I'm telling you, as an epidemiologist, you didn't follow a scientific method. I think that intimidates some judges, and they have this ability at their fingertips to try to address it. I think we even point out in the monograph that there are certain organizations that have offered to help find neutral experts.
And medical schools, maybe, if it's epidemiology, maybe there's a way for a judge to reach out and find, people who aren't already associated with a cause or whatever, to address, like, take way back the breast implant litigation, right? Silicon caused all of these autoimmune diseases, and there was that famous doctor from, I think it's Harvard, Dr. Marcia Angel, I think her name was, and she wrote the leading piece on epidemiology and basically said, no way. But maybe before that even happened, the courts could have been looking to see whether there were experts in epidemiology at medical schools who weren't already sort of associated with, testifying for plaintiffs or testifying for defendants, who could start evaluating the data or the reliability of what each side's witnesses were saying on the epidemiology.
And part of this goes back, when you mentioned that, part of this goes back to the quote you read at the beginning of the presentation here from Judge Posner. That law lags science, it doesn't lead science. It takes time for science to develop. And so judges could use some help, I think, from experts to explain that to them. I think a lot of times we see a study come out in the press. The next day you have ads on TV looking for plaintiffs claiming injury as a result of whatever the substance is. But science is more exacting than that. And sometimes just one study is not giving you what you need to really come to a scientifically valid conclusion.
Maybe this is blasphemous, but maybe the trade-off ought to be, we'll extend the statute of limitations and wait for the science to catch up, because it is a bit disconcerting if you've got, let's say I do a lot of FELA litigation. There's a 3-year statute of limitations for FELA claims. And so let's say you bring your claim within 3 years of, being told you've got this cancer or whatever, and, maybe it was caused by something on the railroad, you don't know. But maybe we should say, okay, the trade-off for a rigorous application of the scientific method where you need lots of data, you need, thorough peer review and all of that, is maybe for those kinds of claims, the statute of limitations may need to be extended somehow. And I probably will get fired by all my clients for saying that, but it just seems to me, thinking out of the box, to get the right result in the end, you may need to make those trade-offs.
Another question from an online viewer. I don't want to send us down the rabbit hole of Dalbert versus Fry, but the question is it more important to have an effective gatekeeper than whether it matters whether a state applies Dalbert or it applies Fry?
Well, I would say it probably depends on how the state applies Dalbert or applies Fry. Some judges under the Fry standard, it was kind of it was so abstract as to whether the methodology was generally accepted. So you would say, well, he was using epidemiology, and epidemiology is generally accepted, so therefore we're going to let him testify. Dalbert, I think, is a little bit more exacting because it gets at the issue of reliability. And so, I mean, there could be some judges who apply a very strict Fry standard, but I think the Dalbert standard gets more at the issue of whether the testimony should be given to a jury, whether it's reliable enough so that a jury could make a proper determination in weighing the evidence. There needs to be some kind of threshold there before that happens.
And I would add to that, cum ho, meaning Fry just applies to scientific evidence. In the states that still apply it, you get no help for any other kind of expert testimony. And so, we haven't sort of talked about some of the other topics in the monograph, like insurance bad faith, but, that would have no, cum ho is a game changer when it was decided for insurance bad faith cases, although I can't say that courts are routinely excluding testimony, but before cum ho, and in the Fry states anyway, if it wasn't scientific evidence, it just gets admitted. So the expert can pretty much do whatever he or she wants within the bounds of relevance and maybe Rule 403. So Dalbert / cum ho gives you a federal rule that all expert testimony needs to be subjected to these screens.
I'm going to move into one of the final principles that was discussed in terms of the gatekeeping tools, and that is having things on the record. And it sort of speaks to what Craig was saying, that some of these Science Day things are off the record completely, and that's obviously not very helpful to parties. Are most of these hearings on admissibility, Dalbert hearings, are they normally done on the record?
I think the answer is yes, at least all the ones that I've been involved in, and I think that's something you definitely want to insist upon, both for the record in the trial court and then on appeal.
Yeah, I think in federal court it's probably standard practice. Some state court judges or at least in the old days, they were very comfortable just talking things through in their chambers, and it would never see the light of day. But I think, as Craig says, you really have to push them to do that, or else, what are you supposed to do on appeal if you have to appeal?
You had mentioned the issue of medical causation, which is one of the case studies that monograph goes through, and how important it is to use the principles that you lay out in the beginning of the monograph. What actions can defense lawyers take to prevent courts from subsuming the general versus specific causation that has to be gone through, or you have to determine general first and then specific after that?
Well, one of the things you could do, and we talked about this a little bit earlier, to make sure you're addressing these separately is some type of lone pine order, where maybe up front you do a general causation challenge. If the court allows that testimony in, then maybe you have a separate hearing later on specific causation. So that's certainly one way you can maybe try to force that issue. But I think it's important that you impress upon the court the difference between those two inquiries and the importance that both of those inquiries have to be satisfied before you've really established causation. General causation is kind of a subcategory. Ultimately, what you have to prove is specific causation, that the plaintiff, whatever the action of the defendant that you're alleging was wrong, caused his injury. But as part of that, you have to show, in medical causation cases at least, or toxic chemical cases or pharmaceutical cases, that the agent is capable of causing those injuries in people. You can't skip over that first step to get to the second step. That's something that has to be decided.
In terms of general causation, you had said in the monograph that it's extremely important for judges to draw the admissibility line at validated knowledge rather than scientific plausibility. Can you describe the distinction between those two concepts?
Yeah. The focus, as we've been talking about, is on methodology here. And the methodology is that you're looking to assess is whether they followed a scientific methodology in reaching the results. So you have to, and that's the way science develops. Science starts with a hypothesis, and then it tests that hypothesis, and through the course of testing and synthesis of all the evidence, you ultimately could come to a conclusion. Does the evidence show causation or does it not? So the inquiry that the judge has to make has to be focused on, was there a scientifically valid synthesis of all of the evidence to support the expert's opinion? There was a recent case, I think, that addresses this just a couple of weeks ago, the In re Viagra and Cialis case out in the Northern District of California. That case involved an allegation that Viagra and Cialis promote melanoma. So they would aid in the progression of melanoma through a certain enzymatic pathway. I think it's called PDE5, or it's a PDE5 inhibitor. And the court went through the evidence that the plaintiffs were relying on and noted that there were several studies that reported some associations between these PDE5 inhibitors and melanoma progression, but ended up excluding that testimony because the experts did not validly synthesize that information. In this particular case, the experts were using something called the Bradford-Hill criteria to support their argument that these studies that had been done validly support a causal inference. But as the court pointed out, in fact, while the experts had claimed that there was a very strong association between Viagra and the melanoma outcomes, in fact, the association was very weak. And certain other of the criteria from Bradford-Hill weren't established at all, and plaintiffs' experts had no explanation for how they could find causation without that. One of the most important being there's a lack of dose response. And so in that case, I think the judge rightly focused on what was the method that the expert used, and were they reliably using that method? The judge found that they weren't. And that's really the difference between just a hypothesis or just evidence that falls short of causation and when you have when you really have validated knowledge. Is it derived by a reliable scientific methodology?
Is there a good example out there of a court doing a faithful job in looking at the evidence when it comes to specific causation, where there's obviously a somewhat higher standard for the admissibility of evidence?
Yeah, I think there are a number of examples. We mentioned some in the monograph. I had a case 2 weeks ago. I argued a Dalbert motion which involved both general and specific causation. This was a case where a plaintiff claimed that exposure to a certain chemical had caused him to have elevated cholesterol levels. His expert, an occupational medicine physician, had reviewed an agency review of the issue. The agency review had reviewed almost 1,000 different papers on the subject. They came to the conclusion that there were certainly studies that showed associations, but it wasn't sufficient to prove causation. So this review was the only review that this expert had looked at. He was claiming there was causation, but the review that he relied on said the evidence wasn't sufficient. The court obviously didn't find that sufficient to prove causation. But on the specific causation issue, he claimed that this chemical was the only known risk factor for this person's elevated cholesterol. During deposition, he had to concede that in fact, age, we can name a lot of confounding factors for high cholesterol. Age, diet, exercise, weight, and family history, all of which in this person's showed up as a risk factor in this particular person. And the expert conceded that he couldn't rule out most of those. And based on that, the judge struck his testimony, and he won't be testifying at trial about that issue. But I think that's a good lesson. I think it was a good job that the judge did in that instance to, again, focus on the methodology. As we talked about earlier with, I think Evan mentioned it, with the differential etiology, the focus is on how they arrived at their opinion.
I want to shift a little bit and spend a little bit of time on the bad faith litigation issue, which I thought was one of the more fascinating sections of the monograph. And as Evan said, just certainly is a testimony to the importance of the Cumho decision, because you didn't have that kind of expert testimony much in bad faith cases, and you do now. One of the things that's stressed in the discussion of that area is the judge's role in assessing expert testimony versus the jury's role in assessing expert testimony in those kinds of cases. Why is that a critical issue in bad faith litigation, especially?
It's important in bad faith litigation because when push comes to shove, the real reason these experts are hired is to serve as the mouthpiece for the plaintiff's lawyers and to stitch together their various documents that they obtained during discovery to tell a story of, rampant bad faith and corruption within the defendant. I mean, the goal here is to have somebody under the guise of expertise and neutrality telling their story for them. And so little of their testimony actually goes to what is truly within the expertise of an insurance claims expert. And so to me, and I've been involved in that kind of litigation for maybe 25 years, and it became a cottage industry. There were certain people who would appear in case after case whose job it was to spin the bad documents, and then they just put a little icing on the cake by saying, well, I'm testifying about the standards for claim handling. And so it's critical for the court to sort of cut through all of that and say, no, you're not going to be a second plaintiff's lawyer in this case. No, you're not going to tell their narrative for them. They can ask you a question about what is the proper, amount of time that should be taken to respond to an inquiry or whatever the practice is at issue. But beyond that, it exceeds their domain. And so it's really, so the gatekeeping function there, it's sort of, in many cases, it's not even about is it reliable, although you could frame it in terms of reliability. For example, when they say this insurance company was deliberately out to save money on claims by cutting corners or whatever, by, doing whatever they're alleged to have done in that case. And that's sort of mind reading. And you could say there's no reliable methodology for taking a company's documents and inferring from that a corporate intent to cheat. And we've made the argument in that way. You could have done it sort of without framing it in terms of whether there's a reliable methodology, but this is another way to illustrate what the problem is for the judge. And if the judge is used to dealing with experts in other contexts, it may resonate. So I was interested earlier today, though. I thought this problem was sort of unique to the insurance industry, but Craig was telling me about a case in which he was involved, in which the expert was an environmental case, or
Yeah, basically an environmental case.
and the expert's there to tell the narrative and come up with this was a bad company story.
Right, I mean, the expert had taken documents and interpreted the documents as to what the company was thinking when it was publishing certain information and doing certain studies and kind of putting a gloss on the documents. In that particular case, we did manage to convince the judge to stick the expert to the facts and to his expertise. He was an epidemiologist, yet he was talking on about how he believed certain people at the company were not being forthcoming about the findings of their studies, which really was not proper subject of expert testimony.
Have there been instances where decisions at a lower court are overturned in an appellate court if the judge didn't keep some of this, glorified second plaintiff's lawyer testimony out in bad faith cases?
I'm not sure I'm recalling any offhand. I mean, I think a lot of times these battles need to be won at the trial level. As we know, it's an abuse of discretion standard on appeal, and often on appeal there are a lot of other fish to fry. So it's not always the case that the defendant is going to include that in the issues, even if there is a ruling that seems wrong. So I mean, a lot of times when we brief this, the plaintiff's lawyer would come to the hearing and say, we have no intention of doing that. And then the fight becomes holding them to that. But when you file a motion in limine, whether it's a Dalbert motion or any other motion in limine to exclude or limit either evidence or argument, a lot of times the other side will just agree that they won't do it, and then so you win by default almost. And I think that's happened in a number of the insurance cases where we've been lucky enough to be involved at the motion stage.
We'll finish up with some general questions. The first one is the second half of one of our online viewers' questions. What avenues exist to teach judges to be effective gatekeepers? And I guess I'd add, you have situations like in the state of Florida where they were under the Fry standard, and then they were under the Dalbert standard, and then they went back to Fry, and then just this year they went back to Dalbert, and judges may not have even known what the difference was to begin with. So how can, other than reading the monograph that we published that you guys wrote, what else can judges do to better educate themselves?
Yeah, that's what we would recommend.
Well, it should be a subject of judicial conferences, right? They have them every year. There's no reason they can't have some education on the topic at the judicial conferences. And then, it's the lawyer's job as advocates for their clients to make sure the court understands it when they're briefing it. And, if you think you're dealing with a judge who isn't really up to speed on it, then, the first part of the brief is going to have to educate them.
Yeah, and maybe you want to make sure you get a Dalbert hearing for that, where you can have time with the judge to interact and answer questions, to make sure he understands and is on the right track as to how he's approaching the issue.
Yeah, maybe even that, the first case management conference, you could say, look, Your Honor, this is coming down the pike. this is clearly going to be a case where the plaintiff is going to need to introduce expert testimony if they are going to try to get past summary judgment, and then, we're going to have Dalbert motions in the Dalbert hearing, and so we're going to have to build that into the case management order, and we will need a substantial amount of time. We anticipate we'll need a substantial amount of time for the hearing because the science is complex, or so there's ways to start sensitizing them early in the case.
It would be fair to say that multi-district litigation has more of this than your average judge's docket. Would it be fair to say that at least MDL judges that are among those that the JPML appoints should be more versed in science in general than your average trial judge?
You would certainly hope so. I think, and I would say for most of the judges, they have certainly put aside the time to address those issues. So I haven't been in an MDL where the court just ignored Dalbert and blew through it. But you get different judges who take their responsibility or interpret their responsibility differently.
Yeah, I think my experience is the same. I think judges are generally conscientious, and certainly in the federal courts. And if they have been given responsibility for an MDL, I think they want to handle it right generally. They may wish it had never come to them, but once it comes, I think they're going to try as well as they possibly can to get it right, and they know the importance, and they know that their rulings are going to affect dozens or hundreds of cases. So the stakes, the magnitude of the stakes, I think, cause them to put in the necessary effort and time.
Does it surprise you that there hasn't been a case before the Supreme Court since 1999 that focuses solely on scientific evidence and the application of the standards? Obviously, the court set out the standard in Dalbert that was so monolithic that it was incorporated into the federal rules formally. So I imagine the Supreme Court would expect that lower courts would know how to apply it correctly, but there's so much of this out there. Does this surprise you?
I guess it doesn't greatly surprise me. I mean, the court is looking to resolve circuit splits on sort of clear questions of law. A lot of this has to do with application of Dalbert. We mentioned earlier that there's this issue of whether you have to apply it strictly at the class certification stage, and if the split on that remains, then I would anticipate at some point they'll have to step in and decide it. They have certainly hinted at the answer, I think, in some of their class action cases recently, and we talk about that in the monograph. But aside from that, and maybe Craig was talking about the two-step requirement of there being a reliable method, and it has to be reliably applied. It could be that there's enough disagreement or misunderstanding of that in the lower courts that could percolate up at some point. But my sense is that the court probably thinks it's done what it needs to in this area.
Yeah, I mean, I think the ultimate Dalbert inquiry is a very fact-based inquiry, case-specific. The Supreme Court, I don't think, sees its role as stepping in to do that kind of analysis. They think maybe they've laid out the tools to do that already. But there could be situations where you get some kind of circuit split on how they approach that would be clean enough. It just hasn't, to date at least, gotten to the court in a way they want to take it.
So the advisory committee on the rules of evidence has been asked to take a look at a possible addition to the rules that clarify the question of that questions of sufficiency of basis and reliability of application are issues of admissibility, not weight, and are governed by the preponderance of evidence standard under Rule 104A. Is this something that the courts have been confused about, or is this something that you think is going to get more? Because I got to sort of wait to see how the courts look at it more before they take that kind of a step.
Well, my experience is That's a central question in most Dalbert inquiries. Is it weight or is it admissibility? And I think we talked about earlier, our interpretation, and I think which is consistent with the Supreme Court's, is that there's a threshold question that you have to answer before you get to that issue, and that is, did they use a reliable methodology in arriving at their opinion? That's what makes it admissible or not admissible. And I think there is some confusion out there in the courts on this issue. Some judges feel, I think, that juries are capable. Maybe they feel unqualified to make these calls, and they feel that the lawyers are very good at cross-examining and pointing out these flaws. So why not let the jury decide whether these are valid flaws or not? But Dalbert really does place that requirement on judges because it is a scientific call, and it's not something that juries can just do on their own. So I would say I do think there is some confusion, but I'm not sure that it should be there. I think the law is already pretty clear on that.
Yeah, it wouldn't trouble me at all if they've just fixed it in the rule. I mean, that's what they did with, the prior amendment to the rule was basically just taking what the Supreme Court said in Dalbert and sticking it into the rule. So why not clarify and avoid the need to have Supreme Court intervention?
So last question, when you were developing the information and doing the research and then putting this monograph together, is there anything that surprised you that you didn't really realize was as much of a problem, or that hasn't received a lot of attention when you were doing research for it?
That's interesting. One of the areas that I worked on, and we each wrote different sections of it, but one of the areas I worked on was Rule 706 and the tools that judges had in their quiver. And I'd have to say that there's more there than I thought that was there. I was very familiar with Rule 706, but there's a lot of other ways judges can become educated, including hiring a special master or hiring a science advisor for them. And there are certain ways you can pay for that. Maybe even the parties don't have to pay for that, but I think most judges would probably put that on the parties. But that surprised me that there's a lot of these tools out there, maybe more than I was aware of at the time, but no one's really taking advantage of them. We just don't see that very much in these cases. And I think that would potentially improve the rulings if there was more scientific help in these decisions.
I would second that. I mean, the sections, I stitched it all together and edited the thing. I was familiar with what everybody was saying in their sections from having done this for a while, but what really jazzes me is this challenge of trying to come up with another way to resolve these issues by neutral experts or some other methodology that the court really would take more of a role in than sort of passively waiting for each party to attack the other side's experts and then having to decide it. So it's not that I would say I wasn't aware of it, but it was certainly one of the things that engaged me the most during the process.
Thank you both for joining us today. Again, thank you for the work that you both did on the monograph. Same thing to all of your colleagues who are co-authors of it, and thanks to Mayor Brown for allowing you to spend all that time pro bono for putting it together for WLF. Those of you who are online, if you've joined us late or you want to watch this again, parts of it, it'll be available online as an archive file a little bit later this afternoon. Certainly let colleagues and of yours know that it's something that's worth watching. Thank you again.
Thank you.
Thank you.